Assalamu alaikum. Welcome back to Hilaal Live. Thanks for joining us on channel 347 on DSTV. And if you're live streaming on our live stream channel, www.hilaal.tv. Thanks for watching so far. And we've got a WhatsApp line open. You're welcome to send us a comment, a query, 079 085 2511. In studio, we'd like to welcome back Advocate Yusuf Khan Dalwai. Assalamu alaikum.
Wa alaikum salam, Luqman, to you and your viewers as well.
Jazakallah so much. Only a pleasure. Look, last week's edition, where we spoke about wolves, September being Wolves Month, we just prolonged it a little bit because we were off air with our regular programming. But from that, it highlighted the fact that not too many people or need advice with regards to deceased estates. And that always seems to hold up the reading of the will and how the will gets dispersed accordingly as well. Now, if we look at the deceased estates, all right, what is the administration that goes into a deceased estate?
Okay, the administration of deceased estates is a legal process in which we have to follow in terms of the South African legal system, whereby we wind up that particular estate, whether it's paying the debts of that estate, whether it's securing the assets of that estate. So all that falls under the category of the administration of it. Anything pertaining to the estate of the deceased. So the moment your loved one passes away, automatically you are now in a position to obviously take it to the next step, and that is to report that respective estate and comply with the relevant procedures and legal procedures in respect of winding it up.
The amount of administration, but the terms and what needs to be put into that deceased estate that our law recognizes. Can you run through that very quickly?
Okay, so what is very important is the will. Okay, so the original will is important to have at hand, and the person that would normally proceed in moving the estate forward, it would be the nominated executor, or a family member, or the surviving spouse, or a child, or an heir. Would usually step up and state, okay, fine, here is the will, and we are now going to open the will, and this is what our father or mother or brother or sister has testated, in his last will and testament, and this was his wishes, and this is how it needs to be carried out.
Brilliant. Now, you mentioned that it needs to be reported.
Yes.
Where do we go to report this?
So once, like I said, the nominated executor in the will, and remember we did the contents of the will last week, and one of the clauses is the nomination of an executor. Right, so the executor would normally proceed with completion or the completion of the forms. So usually it happens in the presence, usually you would go to an attorney and do it, but let's answer the attorney question a bit later. So the reporting documents has to be completed. For example, the death notice has to be completed.
And that normally the family handles that?
Normally the family would handle that, right? You'll wait on the death certificate from the undertaker. Once you've received the death certificate, then you automatically in a position to report the estate. So you need to collect the will from wherever the will is, or whoever had it in safekeeping. You need to get the IDs of the deceased, the IDs of yourself if you are the nominated executor, and IDs of the surviving spouse and the heirs in the estate. Right, copies sufficient, obviously, and completing the death notice, the inventory, the list of assets and the list of liabilities.
That's also very important. That was going to be my next question, because when you touched on, the death notice, sometimes people don't know that you need to report that to your creditors or debtors. How does that process affect the estate if it's not reported properly?
Yeah. So once it's there's no. If it's reported, it's reported,
Okay.
right? So it's important that there's a set of required documents that needs to be completed, and then submitted or lodged at the office of the masters.
Okay.
Right. So the masters will then assess the reporting documents and capture it, and then issue the letter of executorship.
Okay, all right.
All right.
Okay, gotcha.
That means that that's been nominated in terms of the will now have authority to act on behalf of the estate or on behalf of the deceased.
Okay. Now, the one question I have is, for example, somebody now passes away and they've got a whole lot of debt. They've got accounts with A, B, and C companies, but I don't know all these companies that they have accounts with. How do I find that out?
So it's important that you leave a list of your creditors and who you owe money to. It makes things easier with your with your spouse or the executor whom you nominated. It's important that that information is at hand.
Right.
In the absence of that, okay, so part of the winding up of the estate, once the letter of executorship has been issued by the master's office, then an advert needs to be placed in the local newspaper, okay? Advert in terms of Section 29, and that is the notice to all the creditors.
Right.
Right? So it goes into the local newspaper, and it also goes into the government gazette, the legal gazette.
Gotcha.
Right? So it lays, that advert will be there for about 30 days, and during that period, the creditors will contact you.
Okay.
And it will contact your attorney, because there will be a contact number in the advert, and the creditors are now in a position to submit a claim. Okay, or submit the outstanding debt of the deceased.
What happens in the event that the estate doesn't have sufficient funds to settle the debt?
Now that becomes a bit problematic, down the line, especially if there's not sufficient funds. Then the estate is not in a position to be wounded up, and it then depends on the circumstances, what assets there are. Let's say there is a property, and the liabilities are just way too much. Then, unfortunately, the property, the master's direction would probably be to sell the property in order to settle the estate or settle the liabilities of the estate. So the liabilities must always be settled first before anyone may benefit from that.
Estate. Gotcha. That's very, very important. And I think families need to be aware of the process. Because you don't want somebody coming to knock on your door in 2 months' time and say, look, we do have a claim to an asset or funds in the estate. Can you please settle? Because then the family just is not in a position to do that.
Yeah, and we shouldn't avoid certain creditors. If you are aware that there's a creditor, let's say there's a outstanding credit card account or a personal loan account, and that creditor did not come forward, I mean, that that creditor is one of the creditors and the liability. Inform them and ask them for a certificate of balance so that that debt can be paid.
Okay. We have the WhatsApp line open if you'd like to join us and be part of the conversation, 079-085-2511. We're talking about deceased estates, the relevant information that needs to appear, and also the process of what the family needs to go through when someone passes away. Very important. We've got Advocate Yusuf Khan Dalwai in studio. So send us your WhatsApp on the WhatsApp number 079-085-2511, and Yusuf will try his level best to answer those questions as well. Only WhatsApps, no phone calls, unfortunately. We'd really appreciate that. During this time that the family goes through the winding up of the estate and things like that, a lot of emotions, I would imagine, goes through the family for obvious reasons. They've just lost a loved one. And sometimes processes may not be followed properly, and maybe a step was missed. Are there repercussions for that? I mean, let's take the process we spoke about. And if any one of those steps were missed because the family is just not in the right frame of mind.
Yeah, that is why it becomes important to appoint an agent or an attorney so that they can handle and manage it for you. So a process can never be missed. Okay, because the masters are there to ensure that each and every process is followed in the winding up of that deceased estate. So the masters is there as a safety net. So if you, let's say, innocently omitted something or skipped a process or forgot to place an advert, the masters will kindly remind you in a query letter that kindly provide us proof of your advert. And if not, obviously attend to it. You know. So there is a checklist, there is formalities and requirements, and all that has to be met.
Brilliant. We're chatting to Advocate Yusuf Khan Dalwai on our legal slot on Hilaal Live. Join us on the WhatsApp line. If you have a query about a deceased estate, that's our topic today, you're welcome to do that on our WhatsApp line. Send through those queries and Advocate will attend to that. We're going to take a short ad break. When we come back, we continue with our legal slot. You are still watching Hilaal Live. Assalamu alaikum. Welcome back to Hilaal Live. Thanks for watching us on channel 347 on DSTV and on our live stream, www.hilaal.tv. The WhatsApp line is open. It's our legal slot. And our topic today, deceased estate. If you'd like to join us and be part of the conversation, 079 085 2511. WhatsApps only. We unfortunately don't take phone calls during this session. Advocate Yusuf Khan Dalwai, Jazakallah once again for coming into the studio, sharing some very important information. And we've got a couple of WhatsApps and we're going to attend to that very shortly. But to continue with our conversation that we did just before the break, must an attorney be appointed to assist with the administration of a deceased estate?
It's not completely necessary unless you have the know-how on how to report an estate, how to collate the documents, how to place the advertisement in the newspaper, the gazettes, how to develop and draft an L&D account. If you're familiar with the process, and you can do it yourself if you've been appointed as an executor. But generally speaking, and like you said, rightfully said, it's a very emotional period for people losing their loved ones. So it's best to leave it in the hands of an attorney. And the attorney is specialized to wind up estates.
And he's got the necessary people.
Yes, the necessary skill and knowledge and resources in order to wind up your estate. So it's always best to do that.
Okay, good advice. Jazakallah there. I want to get to the WhatsApp that's just come through as well, if we can attend to that. It says, Salam, or my father passed away 10 years ago. How do I go forward with his estate?
Okay, so if he passed away 10 years ago, usually what needs to happen is as soon after the person has passed away, you got to report it as soon as possible. 10 years is definitely not as soon as possible, but it's not too late. You can still proceed in reporting the estate. The masters will just give you a little bit of a look why you're late, and that's it. But you can still continue.
As long as you have the death notice.
Yes, you have the death notice. Look, the death notice you'll have to obviously complete at the time when you're reporting it. So you got to just make sure you have the death certificate, the original will. That is very important. And then the deceased IDs and the heirs IDs and the surviving spouse ID, and then you can proceed with reporting it to the office of the masters or appoint an attorney, and they will in the covering letter explain to the masters why you have taken so long to come to...
all right. So no issue with the 10-year period?
No. You can still proceed.
Jazakallah. I hope that answers your question, viewer. You're welcome to correspond with us on the WhatsApp line 079 085 2511. You're welcome to send us a WhatsApp if you have a query with today's topic, which is deceased estates. Advocate Yusuf, what happens when someone passes on without a will? And I think they call that intestate?
That's correct, yes. So if the deceased have not left a will, or has left a will that's defective and does not comply with the requirements and the formalities of the Wills Act, then that estate will be wounded up in terms of the intestate succession. So even if, for example, the deceased's wishes were that his estate is wounded up in terms of Sharia, at that juncture, it won't be able to comply with that.
Okay.
It will have to be in terms of intestate succession.
Gotcha.
So intestate means that the whatever the asset value is, less the liabilities, gets distributed amongst the heirs.
Surviving heirs.
Surviving heirs in equal shares.
Okay.
Okay. There's obviously what we call per stirpes, how it's divided. If there's a surviving spouse, and if there's a second wife, and the child share, what is more, and I think that we must have a show on that alone.
I think so too.
Yeah, because it's quite in detail.
Yeah.
And that would be in equal shares. However, if the deceased wishes at that juncture or during his lifetime was that his estate be wounded up in terms of Sharia, it can still be done.
Okay.
Although you got to reflect in your liquidation and distribution account
to cater
for the intestate distribution. There is one more option, and that is called the redistribution agreement.
Okay.
So you can get a certificate from the ulama body stating that this is the distribution for in terms of Sharia, and that distribution can be reduced into an agreement.
Okay.
What we call a redistribution agreement.
Okay.
But all the heirs has to agree. If one heir disagree, then unfortunately it cannot go ahead.
Right.
If all the heirs are in agreement that this estate is going to be wounded up in terms of our Sharia, and then that would be
But that
good.
also differs from mother to various parts.
Yes.
And maybe we could have a show on that.
Yes.
And maybe go through how the percentages work with regards to the redistribution of one's assets.
That would definitely be beneficial to our viewers as well.
There's so many complications that can come up when there's no will. And I think to a large degree, our community is reluctant to draw up a will, primarily because it reminds them about death. And it's a topic that nobody wants to speak about. Unfortunately, it's part of life, and they said there's only two things that's guaranteed: taxes and death, and death and taxes. And we're making light of it, but it's so integral that a will gets drawn up so that the surviving heirs knows exactly what to do with your estate.
It is extremely important. That's why we emphasize in our wills program last week, and we mentioned that you cannot rule from the grave.
Definitely.
And that is why we need to put our wishes in writing and in the will. So it's important that we do that and consider it. Even if you have a small
estate.
A simple thing like your vehicle. If there's no letter of executorship issued or letter of authority issued, no one can draw the license of that vehicle. You cannot sell the vehicle. Even if it's just a small vehicle. Let's take the smallest vehicle, an old 1972 Mini.
Gotcha.
Right? You can't transfer it. You can't sell it. You can do absolutely nothing.
Goes to the scrapyard.
So you have to go to the masters to report that estate, right? In order for you to get the authority to act on behalf of the estate and go and deal with whatever licensing or selling of that vehicle. Now, if you did not intend for that vehicle to go to your first son, for example, and your first son is living in another country, and your second son is living in another country, and your third son you don't know where he is, and your fourth baby son, comes along and he decides he's going to do everything.
Right. Okay.
What's going to happen? There's going to be a big problem in that household.
Absolutely.
Who gave him the authority to go and report the estate, number one, without our consent and nominating him, because maybe he took a nomination just from one person. And he sold the vehicle and the money's in his pocket. So you're causing a problem. This is just one small little item.
And this is why Wills Month was promoted as well.
Exactly. It is there to facilitate a process that is in order, that is fair, that is just, and that whatever your wishes were is executed.
Yeah, yeah. That's important.
Because if you don't have it, your children are going to fight.
Absolutely.
My dad said that Rolex watch will always come to me.
Right.
Now you don't leave, you don't have a will, that Rolex watch has to be sold, right? And the proceeds of that sale, that money must be distributed equally amongst the surviving heirs.
What happens in that process where the executor of the will also passes on? Can a new executor be nominated?
If the executor of a will passes away, a new executor may be appointed.
Okay. And
so all the heirs would then complete a nomination form. I see. And they would nominate one person.
Okay.
Right? Let's say another brother or cousin or even the attorney to act as the executor. Okay. Right? And if they can't agree, then the masters may appoint one.
I see. Okay.
If the parties are in conflict and in dispute with each other.
Okay.
Because a lot of people are under the pressure, now I'm not going to give it to that one because he's going to run away with our money and our property. It actually doesn't work.
And when it comes to our finances, we're very, very tight-fisted with that. Very quickly, before we end, Advocate, what is the entire process of winding up an estate? So if you can run through that quickly.
If I can just quickly run through it in a very short description. So first, the reporting documents, we've mentioned that. Once a letter of executorship has been issued by the masters, two things has to happen immediately. One, the advertisement has to be placed in the newspaper and the government gazette. An estate late account has to be opened.
Right.
Right. So now you wait that period, 30 days, and you wait for your creditors.
Right.
Right. Anyone that is claiming anything from the estate will appear during that period. Okay. Once you know what you've secured, your liabilities, you now then draft the liquidation and distribution account. So that is an account that basically sets out your income, the total asset value, your liabilities. Liabilities would include whoever you owe monies to, liabilities towards the master, the expenses of winding up the estate, the attorney's expenses, conveyancing fee if there's going to be transferring cost, and any estate duty estate duty that you may be liable to, right? And then the remaining balance would be distributed in accordance to the will.
Okay.
Right?
Gotcha.
That would be set out in that account. After that, it gets lodged to the masters. The masters will have a look at it and do the calculations and check if everything is in order, the checks and balances. If they are happy, if the masters is happy with the calculations, they would then send you a correspondence to say they are happy, you can proceed with the advertisement. That is the second one.
Gotcha.
In terms of Section 35. Now that advertisement is there to inform people that there's a L&D account, a liquidation distribution account, that's available for inspection.
Gotcha.
So anybody who wishes to inspect it can come and inspect it, and if they have objections, they need to do so.
Okay.
And that lays at the closest court that's within your jurisdiction for a period of 21 days. Okay. The court will issue a certificate that there were no objections, goes to the masters. Master then says, fine, everything is good, you may proceed and distribute.
Brilliant. Jazakallah so much. Quite a process, and I'm sure it's there for a reason.
Yes.
So that things can flow very, very easily. Jazakallah. Have a great
You're
evening.
Welcome.
And that's how we end our legal slot with Advocate Yusuf Khan Dalwai. From the Cape Town team, Sohail Barnes and myself, Luqman Shadrack. Have a great evening. Assalamu alaikum.